What happened in courtroom 12B will go down in legal history. Judge Tanya Chutkan thought she had Congresswoman Jasmine Crockett cornered during a high-stakes constitutional hearing. But what Jasmine pulled out next completely flipped the entire trial and left the judge speechless. This wasn't just a legal maneuver, it was a masterclass in constitutional law that shocked everyone in the room. Before we dive into this incredible story, hit that like button and subscribe so you don't miss the latest political drama. Trust me, you're gonna want to see how this ends. The federal courthouse in Washington, D.C. was buzzing with tension. News cameras lined the steps outside, reporters clutching their microphones, waiting for any update from what legal experts were calling the most important constitutional case of the decade. Inside, the marble halls echoed with hushed conversations, as lawyers, politicians, and concerned citizens packed into the galleries. At the center of it all was a battle between two powerful women, Judge Tanya Chutkan, known for her strict interpretation of federal law and no-nonsense courtroom style, and Congresswoman Jasmine Crockett, the fiery Texas Democrat, who had built her reputation on fearless advocacy and brilliant legal arguments. Judge Tanya Chutkan had earned her reputation as one of the toughest federal judges in D.C. Appointed during the Obama administration, she was known for running her courtroom with an iron fist. Her sharp wit and extensive legal knowledge had made her a formidable presence on the bench. She rarely smiled during proceedings, and lawyers knew better than to come unprepared to her courtroom. Chutkan had a particular way of handling cases that involved political figures. She believed in keeping politics out of her courtroom, and had little patience for what she saw as grandstanding or theatrical behavior. Her rulings were always meticulously researched, and she took pride in her reputation for fairness, even when it meant making unpopular decisions. On the other side of this legal battlefield stood Congresswoman Jasmine Crockett, a rising star in the Democratic Party. At just 43 years old, she had already made waves in Congress with her passionate speeches and her background as a civil rights attorney. Before entering politics, Crockett had spent years fighting for justice in Texas courtrooms, winning case after case for clients who couldn't afford high-powered legal teams. Crockett was known for her quick thinking and her ability to find creative legal solutions to complex problems. Her colleagues often joked that she could argue constitutional law in her sleep. She had a gift for taking complicated legal concepts and explaining them in ways that ordinary people could understand, which made her incredibly popular with voters back home in Texas. The case that brought these two legal minds together was explosive. It centered around Executive Order 4082-3, a sweeping directive that gave federal agencies unprecedented power to override state laws in matters of national economic security. The order had been issued in response to what the administration called a crisis of economic coordination between federal and state governments. The executive order was particularly controversial because it essentially allowed federal bureaucrats to nullify state regulations that they deemed harmful to interstate commerce. Environmental protection laws, labor regulations, and even some civil rights protections could potentially be swept aside if federal officials determined they interfered with economic efficiency. Several states had immediately filed lawsuits challenging the order, led by a coalition that included both Republican-governed states concerned about federal overreach and Democratic-governed states worried about the erosion of environmental and worker protection. The case had quickly made its way to federal court, where it landed on Judge Chutkan's docket. What made this hearing particularly significant was the unusual coalition of opposition. Conservative legal scholars who typically supported strong executive power found themselves aligned with progressive activists who normally advocated for federal intervention in state affairs. Both sides recognized that this executive order represented a fundamental shift in the balance of power that could set dangerous precedents regardless of which party held the White House. The business community was divided as well. Large corporations generally supported the order, seeing it as a way to cut through regulatory red tape that varied from state to state. But smaller businesses and local chambers of commerce worried that it would eliminate the competitive advantages that some states had built through smart regulation and efficient governance. Labor unions were unanimously opposed, fearing that hard-won worker protections could be eliminated with the stroke of a federal pen. Environmental groups saw it as a direct assault on decades of progress in protecting air and water quality. Civil rights organizations worried that anti-discrimination laws could be weakened if they were deemed economically burdensome. What made this hearing special was that Crockett wasn't just observing. As a member of Congress, She had been called to testify about the legislative intent behind certain laws that were central to the case. Her unique position as both a sitting legislator and an experienced civil rights attorney made her testimony potentially crucial to understanding how Congress had intended federal-state relationships to work. The stakes couldn't have been higher. The outcome of this hearing would determine whether the executive order could stand, potentially affecting millions of Americans who depended on state-level protections that could be swept away. Legal scholars were calling it a defining moment for constitutional law, and political commentators were watching to see how it might impact the upcoming elections. The timing was particularly sensitive because the hearing was taking place just months before midterm elections. Both parties saw the case as a potential game-changer that could energize their base voters. Republicans argued that the executive order represented exactly the kind of federal overreach that voters should reject, while Democrats claimed it showed the administration's disregard for democratic norms and local control. National security experts were also paying close attention, as the executive order claimed to derive its authority from national defense consideration. The administration argued that economic coordination was essential for national security in an era of global competition, particularly with China's state-directed economic model. Critics countered that this was exactly the kind of broad interpretation of national security powers that the founders had warned against. Constitutional law professors across the country had assigned the case to their students, recognizing that it would likely become a landmark decision regardless of the outcome. The legal principles at stake, executive power, federalism, separation of powers, and the scope of national security authority, were fundamental to how American government operates. For weeks, legal teams had been preparing their arguments with an intensity rarely seen in federal court. The government's lawyers were confident they had a strong case, backed by precedent and executive privilege. They had assembled a team of 12 attorneys from the Department of Justice, led by some of the most experienced constitutional lawyers in the federal government. The administration's legal strategy was built on three main pillars. First, they argued that the executive order fell clearly within the president's constitutional authority to ensure the faithful execution of federal law. Second, they claimed that national security concerns justified broad executive action, citing post-9/11 precedents that had expanded presidential power. Third, they contended that the complexity of modern interstate commerce required federal coordination that only the executive branch could provide efficiently. Their brief was over 200 pages long and cited hundreds of cases spanning more than 2 centuries of American legal history. They had enlisted support from several prominent legal scholars, including former solicitors general from both Republican and Democratic administrations. The team was led by Michael Harrison, a veteran prosecutor who had argued 12 cases before the Supreme Court and had never lost a constitutional challenge to executive power. But Crockett had been doing her own research, and what she had discovered was potentially explosive. Unlike the government's team, she was working essentially alone, with only a small staff and the resources available to a member of Congress. But her background as a civil rights attorney had taught her to dig deeper than opposing counsel, to look for the historical context and legislative intent that larger legal teams often overlooked in their focus on recent precedent. Crockett had spent countless hours in the National Archives, poring over congressional records that hadn't been digitized and were difficult to access. She had interviewed elderly former congressional staff members who remembered debates from the night. She had even tracked down family members of deceased legislators to access personal papers that might contain relevant correspondence. Her research had taken her down paths that most lawyers never explore. She studied not just the final text of laws, but the amendments that were proposed and rejected, the committee reports that explained congressional thinking, and the floor debates that revealed the concerns and intentions of the legislators who voted on crucial bills. What she found was a pattern of congressional caution about executive power that had been largely forgotten in modern legal scholarship. Time and again, she discovered that Congress had specifically rejected proposals that would have given presidents the kind of broad authority that the current executive order claimed. These rejections weren't just political disagreements. They were constitutional positions based on careful consideration of the separation of powers. Judge Chutkan entered the courtroom in her black robes, her expression serious and focused. The gallery was packed with reporters, legal observers, and political figures. You could feel the tension in the air as everyone took their seat. Television cameras were not allowed in the federal courtroom, but radio reporters were broadcasting live coverage to millions of listeners across the country. The courthouse steps were lined with protesters from both sides, supporters of states' rights holding signs reading "Stop Federal Tyranny," while administration supporters carried banners declaring unity through federal leadership. Inside the courtroom, the atmosphere was electric with anticipation. Legal journalists who had covered major constitutional cases for decades said they had never seen this level of interest in a federal hearing. The seating area, normally reserved for the public, was filled with law professors, former judges, congressional staff members, and representatives from advocacy groups across the political spectrum. Judge Chutkan surveyed the packed courtroom before calling the hearing to order. She was known for maintaining strict control over her proceedings, and she immediately established ground rules that would govern the day's testimony. Each side would have 4 hours to present their case, with specific time limits for opening statements, witness testimony, and closing argument. The government's legal team presented their case first. They argued that Executive Order 4082-3 was well within presidential authority and that previous court decisions supported their position. Their lead attorney, Michael Harrison, laid out their argument with confidence, citing case after case that seemed to support the administration's position. Harrison began with a sweeping historical overview, tracing executive power from George Washington through Franklin Roosevelt to the modern presidents. He argued that each generation of Americans had recognized the need for strong executive leadership in times of crisis, and that the current economic challenges facing the nation were exactly the kind of situation that required decisive federal action. His presentation was masterful in its scope and ambition. He cited the 1935 Schechter poultry case, but argued that subsequent decisions had moved away from its restrictive view of federal power. He discussed the 19 Filburn decision, which had dramatically expanded Congress's power to regulate interstate commerce, and argued that this expansion logically extended to executive power as well. For nearly 2 hours, Harrison presented evidence and legal precedent with the skill of a seasoned advocate. He pointed to Supreme Court decisions from the 1930s that had upheld broad federal intervention in the economy during the Great Depression. He cited wartime powers cases that had given presidents extraordinary authority during national emergency, and he referenced recent rulings that had continued to expand executive authority in areas ranging from immigration to environmental regulation. His presentation was polished and professional, with carefully prepared visual aids and detailed legal citations. Several observers in the gallery nodded along as he made his points, and even some critics had to admit that his argument was comprehensive and well-researched. He seemed to anticipate every potential objection and had a response ready for each one. Judge Chutkan listened intently throughout Harrison's presentation, occasionally asking clarifying questions, but giving little indication of her thought. She took detailed notes in a leather-bound journal, and seemed particularly interested when Harrison discussed the scope of executive power during national emergencies. Her questions were sharp and focused, demonstrating her deep knowledge of constitutional law. When it came time for the opposing side to present their case, their attorney, Sarah Martinez, stood up and began dismantling the government's arguments piece by piece. Martinez was a seasoned constitutional lawyer who had spent 15 years at the ACLU before joining a prestigious Washington law firm. She was known for her meticulous preparation and her ability to find weaknesses in seemingly solid legal arguments. She argued that Executive Order 1482-3 overstepped constitutional boundaries and violated the careful balance of power that the founders had established. Martinez's presentation was passionate and articulate, but as she continued, something unexpected began to happen that would change the entire trajectory of the hearing. Martinez started by challenging the government's interpretation of the Commerce Clause, arguing that the executive order represented exactly the kind of federal overreach that the Supreme Court had rejected in recent decisions. She cited the 1995 Lopez case and the Sebelius decision as evidence that the court had begun to pull back from the expansive federal power that the government claimed justified the executive order. She walked through decades of federalism jurisprudence, showing how the court had consistently protected state sovereignty even while allowing federal coordination in truly interstate matters. She argued that the executive order's broad language would essentially eliminate the distinction between federal and state authority that was fundamental to the constitutional system. But as Martinez continued her presentation, Judge Chutkan began interrupting her more frequently, challenging her interpretations of various cases and questioning her understanding of executive power precedent. The interruption started as normal judicial questioning but quickly became more pointed and skeptical. "Counselor Martinez," Judge Chutkan said during one particularly heated exchange, "are you seriously suggesting that this court should ignore decades of established precedent regarding executive authority during times of crisis?" The interruptions became more frequent and more pointed with each passing minute. It was clear that Judge Chutkan was not buying Martinez's arguments, and she seemed increasingly impatient with the opposition's case. Legal observers in the gallery began exchanging glances. This wasn't going well for the challengers. Several veteran court watchers later said they had never seen Judge Chutkan so openly skeptical of arguments that seemed well within the mainstream of constitutional interpretation. Then came the moment that would change everything. Judge Chutkan turned her attention to Congresswoman Crockett, who had been sitting quietly at the witness table waiting for her turn to testify. "Congresswoman Crockett," Judge Chutkan said, her voice carrying a tone that suggested she was not expecting much resistance. "I understand you're here to provide testimony about legislative intent. However, given the clear legal precedent we've heard today, I'm not sure your testimony is necessary. The law seems quite clear on this matter." It was an unusual move. Judges rarely dismissed testimony before it was given, especially from a sitting member of Congress. Murmurs rippled through the gallery as people realized what was happening. Judge Chutkan was essentially trying to shut down Crockett's testimony before she even had a chance to speak. Crockett remained calm, but those who knew her well could see the fire building in her eyes. She had spent weeks preparing for this moment, researching legal precedent that she believed could change the entire case. She wasn't about to be dismissed without a fight. "Your Honor," Crockett said, standing up slowly, "with all due respect, I believe my testimony is not only relevant, but essential to understanding the true constitutional issues at stake here." Judge Chutkan's expression hardened. "Congresswoman, I've been practicing law for over 20 years, and I've been on this bench for more than a decade. I think I'm quite capable of understanding the constitutional issues without political commentary." The word political hung in the air like a challenge. Judge Chutkan had essentially accused Crockett of grandstanding, rather than providing legitimate legal testimony. It was a direct shot at Crockett's credibility as both a lawyer and a legislator. The tension in the courtroom was now electric. Reporters were frantically taking notes, realizing they were witnessing something extraordinary. This wasn't just a legal hearing anymore. It was a battle of wills between two brilliant legal minds. Crockett took a deep breath. She knew this was her moment. Everything she had worked for, all the research she had done, all the preparation, it all came down to the next few minutes. She couldn't let Judge Chutkan dismiss her without making her case. "Your Honor," Crockett said, her voice steady but with an edge that made everyone in the courtroom sit up straighter. "I understand your extensive experience, and I have great respect for this court. But I'm not here to provide political commentary. I'm here as an attorney and as a member of Congress to present legal evidence that I believe has been overlooked in this case." Judge Chutkan leaned back in her chair, clearly not expecting pushback. "Congresswoman, unless you have something genuinely new to add to the legal analysis we've already heard, I think we can move on to closing arguments." That's when Crockett made her move. She reached into her briefcase and pulled out a thick folder of documents. "Your Honor, I do have something new. Something that I believe will fundamentally change how this court views this case." The courtroom fell completely silent. Judge Chutkan raised an eyebrow, clearly skeptical, but curious enough to listen. "Very well, Congresswoman. You have 10 minutes. Crockett walked to the podium, carrying her folder with confidence. She looked out at the packed gallery, then directly at Judge Chutkan. This was her moment, and she wasn't going to waste. "Your Honor, the government's case today has relied heavily on executive power precedent from the 1930s and wartime decisions, but there's a fundamental flaw in their argument that goes to the very heart of our constitutional system." She opened her folder and pulled out the first document. "What I have here are the original congressional records from 1947, when Congress passed the National Security Act. These aren't just the final text of the law. These are the actual committee transcripts, the floor debates, and most importantly, the amendments that were specifically rejected." Judge Chutkan leaned forward, suddenly very interested. Even the government's legal team looked concerned. They clearly hadn't expected this. Crockett continued, her voice gaining strength. "The government has argued that the executive order is justified under Section 2115 of the National Security Act, but what they haven't told this court is that Congress specifically rejected language that would have given the president the exact authority he's claiming today." She held up a yellow document. "This is Amendment 47, proposed by Senator Robert Taft in 1947. It would have given the president broad emergency powers, similar to what the current executive order claims. The amendment was debated for 3 days, and was ultimately rejected by a vote of. The courtroom buzzed with excitement. This was the kind of historical evidence that could completely change a case. Judge Chutkan was now taking furious notes, her earlier dismissive attitude replaced by intense focus. But Crockett wasn't finished. She pulled out another set of documents. Furthermore, Your Honor, I have here the personal correspondence between Senator Taft and President Truman regarding this exact issue. In these letters, President Truman himself acknowledged that the type of executive action we're discussing today would require congressional approval. The government's lead attorney, Michael Harrison, was frantically shuffling through his papers, clearly looking for any way to counter this new evidence. He whispered urgently to his colleagues, but it was clear they had been caught completely off guard. Crockett pressed her advantage. Your Honor, the Supreme Court cases cited by the government today, particularly the 1936 Curtis Wright decision, have been taken completely out of context. The court in that case was specifically dealing with foreign affairs, not domestic policy. And even more importantly, the court noted that congressional intent must always be considered when determining the scope of executive power. She walked closer to the judge's bench, her confidence growing with each word. What we have here isn't just a matter of executive power precedent. We have clear evidence that Congress specifically rejected giving the president the authority he's claiming today. We have documentation that even past presidents acknowledged these limitations. And we have a constitutional principle that has been ignored by the government's legal team. Judge Chutkan set down her pen and looked directly at Crockett. Congresswoman, where did you find these documents? Why weren't they part of the original case filings? Crockett smiled for the first time that day. Your Honor, these documents have been in the National Archives for over 7, but they were misfiled under a different classification system, and only recently digitized. I spent the last month working with archivists to locate them because I believe they were crucial to understanding the true legislative intent behind the National Security Act. The impact was immediate and dramatic. Judge Chutkan's entire demeanor had changed. The woman who had been ready to dismiss Crockett's testimony was now hanging on every word. The government's legal team looked like they had been hit by a truck. But Crockett had saved the best for last. She pulled out one final document. Your Honor, there's one more piece of evidence that I believe seals this case. This is a memorandum from the Department of Justice's Office of Legal Counsel, dated just 6 months ago. In it, the department's own attorneys concluded that the type of executive order we're discussing today would be of questionable constitutional validity without explicit congressional authorization. The courtroom erupted. Reporters were typing frantically on their laptops. The government's attorneys were whispering urgently among themselves. Even the court reporter looked up from her machine in surprise. Judge Chutkan held up her hand for silence. Mr. Harrison, I assume you're familiar with this DOJ memorandum. Harrison stood up slowly, his face pale. Your Honor, that memorandum was a preliminary analysis that didn't reflect the department's final position. Crockett immediately responded, Your Honor, preliminary or not, it represents the considered opinion of the government's own constitutional lawyer, and it directly contradicts every argument they've made in this courtroom today. The judge was quiet for a long moment, reviewing the documents Crockett had presented. Finally, she looked up. Congresswoman Crockett, this is extraordinary evidence. Why wasn't this presented earlier in the proceedings? Your Honor, Crockett replied, I requested permission to present this evidence weeks ago, but I was told by the court clerk that my testimony would be limited to 10 minutes, and that documentary evidence needed to be submitted in advance. I submitted a request for extended time to present these findings, but it was denied. Judge Chutkan looked uncomfortable. She clearly remembered the decision to limit Crockett's testimony, and she was now realizing that her attempt to keep the hearing moving quickly had nearly prevented crucial evidence from being heard. Furthermore, Crockett continued, sensing the shift in the room, I believe this evidence demonstrates that the government has not just made legal errors, but has failed to meet their basic obligation to present all relevant information to this court. The DOJ memorandum alone should have been disclosed during discovery. The government's case was crumbling in real time. Harrison attempted to respond, but his arguments sounded weak and desperate compared to the concrete evidence Crockett had presented. He tried to argue that the historical documents were irrelevant, but Judge Chutkan cut him off. "Mr. Harrison, congressional intent is always relevant in constitutional interpretation, and if Congress specifically rejected giving the president this authority in 1947, that's not something this court can simply ignore." Crockett had done more than just present evidence. She had completely reframed the entire case. What had started as a routine hearing about executive power had become a fundamental examination of constitutional limits and government transparency. The immediate aftermath of Crockett's presentation was electric. Judge Chutkan called for a brief recess, during which the courtroom buzzed with excited conversation. Legal experts who had attended the hearing were already calling it a game changer and a masterclass in constitutional advocacy. When court resumed, Judge Chutkan's tone had completely changed. Gone was the dismissive attitude she had shown earlier. Instead, she was focused and serious, clearly grappling with the implications of the new evidence. After reviewing the materials presented by Congresswoman Crockett, Judge Chutkan began, "This court finds that there are substantial constitutional questions that require further examination. The historical evidence regarding congressional intent, combined with the DOJ's own legal analysis, raises serious doubts about the executive order's validity." The government's attorneys looked defeated. Their confident presentation from earlier in the day now seemed hollow in light of Crockett's revelations. Harrison made one last attempt to salvage their position, but it was clear that the momentum had completely shifted. Judge Chutkan continued, "This court is particularly troubled by the apparent failure to disclose the DOJ memorandum during discovery. Mr. Harrison, I will expect a full explanation of this oversight Within minutes of the hearing's conclusion, video clips of Crockett's presentation were spreading across social media. Crockett Constitution began trending on Twitter, with legal scholars and political commentators praising her thorough research and brilliant courtroom strategy. The story dominated the evening news. CNN's legal analyst called it one of the most impressive displays of constitutional scholarship I've ever seen in a federal courtroom. Fox News, despite their typical political differences with Crockett, praised her preparation and legal acumen. Even traditionally conservative legal publications acknowledged that she had uncovered genuinely important historical evidence. The political implications rippled outward like waves from a stone thrown into still water. Progressive activists hailed Crockett as a hero who had stood up to judicial intimidation and government overreach. But her appeal extended far beyond traditional Democratic constituents. Constitutional conservatives who normally disagreed with Crockett's politics found themselves praising her dedication to constitutional principles and proper legal procedure. The story dominated political talk shows for weeks. Conservative commentator Tucker Carlson, despite his typical disagreements with Democratic politicians, devoted an entire segment to praising Crockett's constitutional scholarship. "This is what real legal work looks like," he told his audience. "Regardless of your politics, you have to respect someone who does this kind of thorough research to defend constitutional principle." Liberal commentator Rachel Maddow went even further, calling Crockett's presentation a masterclass in how democracy is supposed to work when dedicated public servants take their constitutional responsibilities seriously. The praise from across the political spectrum was unprecedented for such a polarized political environment. Social media exploded with commentary that transcended typical partisan division. The hashtag #GenConstitutionalScholar began trending alongside Crockett Constitution, with law students and professors sharing clips of her presentation and analyzing her research method. TikTok videos explaining constitutional law concepts saw millions of views, with young people suddenly interested in archival research and historical legal precedent. The most popular video clip showed the precise moment when Judge Chutkan's expression changed from dismissive to shocked as Crockett presented her evidence. The clip was remixed with dramatic music and shared millions of times across platforms, becoming a viral sensation that introduced Crockett to audiences who had never heard of her before. Another viral moment was Crockett's calm but firm response. When the judge tried to cut off her testimony, "I believe my testimony is not only relevant but essential." The clip became a meme template for situations where someone refuses to be silenced, with social media users adapting it for everything from workplace disputes to family arguments. Political comedy shows had a field day with the story. Saturday Night Live featured a sketch where a fictional judge tries to dismiss various historical figures, only to have them present game-changing evidence. The sketch went viral and introduced the story to an even broader audience, with many viewers seeking out the actual footage of Crockett's presentation. Legal blogs and constitutional law professors began dissecting every aspect of the case with an intensity usually reserved for Supreme Court decisions. Harvard law professor Lawrence Tribe tweeted a thread analyzing Crockett's research methods, calling them a textbook example of how historical legal research should be conducted. Yale Law School announced it would be creating a new course on archival legal research based on Crockett's methodology. The American Bar Association took the unusual step of issuing a statement praising Crockett's presentation as an exemplary demonstration of thorough legal preparation and constitutional advocacy. The statement noted that her work reminded the legal profession of the importance of historical research in constitutional interpretation. Law schools across the country reported a surge in student interest in constitutional law and legal history. Applications for summer internships at the National Archives increased by 400%, with students specifically citing Crockett's presentation as inspiration for their interest in archival research. The National Archives itself became an unexpected beneficiary of the attention. They reported a massive increase in requests for historical congressional documents, as other lawyers and researchers sought to follow Crockett's example in their own cases. The archives announced plans to expand their digitization efforts and hire additional staff to handle the increased demand for historical legal research. But perhaps the most significant impact was on the case itself and the broader legal landscape it would reshape. Within a week, Judge Chutkan issued a preliminary injunction blocking Executive Order 4082-3 pending further legal review. Her 47-page decision cited Crockett's evidence extensively, particularly the 1947 congressional records and the DOJ memorandum that had been concealed during discovery. The decision was a legal masterpiece that would be studied in law schools for decades. Judge Chutkan wrote with unusual passion about the importance of congressional intent in constitutional interpretation, noting that the evidence presented by Congresswoman Crockett demonstrates that we cannot simply assume that silence equals consent when it comes to executive power. She was particularly scathing about the government's failure to disclose the DOJ memorandum, writing that the deliberate concealment of legal analysis that contradicts the government's position represents a serious breach of the duty of candor that all attorneys owe to this court. The decision ordered a full investigation into the discovery failures and hinted at possible sanctions for the government's legal team. The government announced they would appeal the decision to the D.C. Circuit Court of Appeals, but legal experts were skeptical about their chances. The historical evidence Crockett had uncovered was solid and well documented, and the DOJ's own constitutional analysis would be difficult to explain away on appeal. Several former solicitors general privately told colleagues that the government's case had been fatally damaged by the disclosure failures. More importantly, the D.C. Circuit was known for its careful attention to congressional intent and historical constitutional interpretation. The three-judge panel that would hear the appeal included two jurists who had written extensively about the importance of legislative history in constitutional cases. Legal betting markets gave the government less than a 30% chance of success on appeal. The victory had immediate practical effects for millions of Americans who would have been affected by the executive order. Environmental regulations that protect clean air and water remained in place. Worker safety standards that had taken decades to establish were preserved. Civil rights protections that guaranteed equal treatment regardless of race, gender, or religion continued to shield vulnerable communities from discrimination. Immigrant rights groups credited Crockett with preventing what they saw as a dangerous expansion of presidential power that could have been used to override state-level sanctuary policy. Labor unions celebrated the decision as a victory for workers who depended on state-level protections that went beyond federal minimums. Environmental organizations hailed it as a crucial defense of the regulatory framework that had cleaned up America's air and water over the past 50 years. More broadly, the case became a symbol of the importance of thorough legal research and the power of historical evidence in constitutional interpretation. Legal education programs began emphasizing the kind of archival research that Crockett had conducted, recognizing that crucial evidence often lies buried in historical records. The story also highlighted the importance of allowing all parties to present their evidence fully. Judge Chutkan's initial attempt to limit Crockett's testimony had merely prevented crucial constitutional evidence from being heard. Legal observers noted that this served as a reminder that even experienced judges need to remain open to new evidence and different perspectives. For Crockett personally, the victory elevated her national profile significantly. She was invited to speak at law schools across the country and became a sought-after commentator on constitutional issues. Her combination of legislative experience and legal expertise made her a unique voice in debates about government power and constitutional interpretation. Other attorneys began following Crockett's model, conducting extensive historical research to find evidence of congressional intent that might have been overlooked in previous cases. The National Archives reported that requests for congressional records from the 1940s and 1950s had increased by 300% in the months following the hearing. 6 months later, the Supreme Court declined to hear the government's appeal, effectively upholding Judge Chutkan's decision. In a brief statement, the court noted that the case raised important questions about the relationship between historical congressional intent and modern executive power, but that the lower court's decision was well supported by the evidence presented. The victory was complete. What had started as an attempt by Judge Chutkan to limit Crockett's testimony had turned into a landmark constitutional victory and a demonstration of the power of thorough legal preparation. Looking back, legal historians began comparing Crockett's presentation to some of the great moments in American legal history. Her ability to uncover crucial historical evidence and present it effectively under pressure reminded many observers of legendary lawyers like Thurgood Marshall and Clarence Darrow. But perhaps the most important lesson from the case was about the ongoing relevance of constitutional principles and the importance of understanding historical context in legal interpretation. Crockett had shown that the founders' intentions, as expressed through congressional debates and decisions, remain relevant to modern legal challenges. The case became required reading in constitutional law courses, not just for the legal principles involved, but as an example of how effective advocacy can overcome initial skepticism and change the entire trajectory of a legal proceeding. As one legal scholar wrote in the Harvard Law Review, Congresswoman Crockett's presentation represents the best of American legal tradition, thorough research, principled argument, and unwavering commitment to constitutional principle. Her victory reminds us that in our system of justice, the quality of legal argument and evidence can triumph over initial assumptions and perceived power imbalance. The story of Judge Chutkan trying to overrule Jasmine Crockett, only to see Crockett reverse the entire trial, became more than just a legal victory. It became a symbol of how preparation, principle, and persistence can overcome even the most challenging circumstances. And for those watching at home, it served as a reminder that our constitutional system works best when dedicated public servants like Crockett are willing to do the hard work of research and advocacy necessary to protect our fundamental rights and democratic principles. If you enjoyed this incredible story of constitutional drama and legal brilliance, make sure to like this video and subscribe to our channel. We'll continue bringing you the most important political and legal stories that are shaping our nation. What do you think about Crockett's brilliant legal strategy? Let us know in the comments below, and don't forget to hit that notification bell so you never miss our latest content.